Artificial Intelligence, Law and Justice, Session 13, second session of this topic. Algorithmic Justice is a topic. Let us do a quick recap of what we discussed in the last class. In the last class, we introduced the idea of algorithmic justice, and then we also discussed as to why this algorithmic justice idea has become very interesting, but at the same time has also evinced a lot of interest among the people. And the origins of this, we also gave a definition. And we also discussed as to how the idea of algorithmic justice is also looked not in the negative sense but also in the positive sense, in the sense it is much more than a criticism. It is also a tool, or it is also an approach that will try to separate certain things, make the companies to understand certain matters which otherwise they would have ignored, and is also something that pertains to use of algorithmic decision making in public services. So, drawing upon the work of Professor Karen and others, the problem of using artificial intelligence as well as automated algorithmic decision making in the criminal justice system was discussed extensively. We also discussed what are the implications for such uses in human rights and how the algorithmic justice thing may not be actually. We need to look at that criminal justice principle, in the sense that algorithmic justice demands that we adhere to criminal justice principles scrupulously when we are using ADM. To put it another way around, we also need to look algorithmic justice as a critique, as something that could provide a solution, and also there's a concept that would be useful given the widespread use of algorithmic decision making across sectors in different applications, particularly various sectors like health, police, criminal justice system, and elsewhere. In this class, we will take that discussion forward and then see what are the other important points in this discussion. Professor Simon Chesterman has identified three challenges posed by opacity. We have discussed about opacity, we have discussed about the black boxness, we have also discussed about the lack of transparency. He says they can result in encouraging or failure to discourage inferior decisions, because the problem is there is no potential for human oversight or accountability. So that itself is something that could make the system to come up with inferior decisions. And certain decisions, normally we wouldn't allow in the regular criminal justice system or any such system, because by explicitly any discrimination on certain identification markers are prohibited. But the problem with the ADM is that such impermissible decision may be allowed on account of the inherent bias in the data or on account of the bias in the algorithmic training itself. So what we normally do, or what normally the judges or the courts or the criminal justice system or the administrative law does not allow or does not permit, would be possible through the back door when we use ADM for such purposes, in the sense that they may create a discrimination based ruling which otherwise would not have been possible or admissible at all. Then it is also possible that when a court gives a decision, is it really legal? Is it really legitimate? That can be challenged, that can be questioned, that can be countered, argued. It can go all the way up to the highest courts. But here the problem is that the process itself, when it gives the answer, is important for us to know. But when that process comes up with answers that cannot be defended fully or that cannot be understood fully, or which could be classified as illegitimate decisions, we are in a serious dilemma or we are in a serious trouble. So the process, due process, the fair process, or as we said, court should treat both parties equally and in equal distance. That may not be possible in algorithmic decision making. One more point which he makes is that, look, the opacity may not be fully 100%. We may need some novel explanations for it. But some decision may not be explained at all. And for some decisions, they should not rely on machines to make them. Or some decisions should always be beyond the scope of the machines to decide upon. So, when we look at opacity and decision making algorithms through these ideas, we find that opacity is not a mere technical problem, that could be solved through better algorithms, better design systems. Rather, opacity should be looked at in a different way, that what happens out of this opacity. When the opacity itself results in some decisions which could be termed as patently illegal, or decisions which a normal court would not have given, or a decision which is there but then it could be explained, or it is no something that can be really understood or explained by anyone. So the idea of using opacity as a mask and then saying, oh, opacity is a technical thing, we can cover all that, we can remove this, the problem would be solved, is wrong. And we need to understand one more thing here. If we talk of opacity and then transparency as totally two different things, and then if we say that 10% opacity is okay, 95% transparency is okay, 5% opacity will always be there in the system, because not everything can be explained. Systems may do a margin of error of 5 to 10%. That should be permissible because system is very efficient and system can handle many things which humans cannot handle. So this is a trade-off. This trade-off should be allowed, particularly in criminal justice systems, particularly in public welfare systems. This is not something that is efficiency versus cost. This is much more than that, and we will see that little later. Algorithmic law is a new concept because algorithmic regulation itself as an idea, as a concept, is not even 20 or 25 years old. So how do we understand algorithms, particularly when they take decisions? In the sense that what do we make sense of them? The editors of a journal, European Journal of Risk Research, pointed out in a special issue, which I am citing here, that algorithms often work as a functional equivalent of a legal rule, similar to a structure of a command and consequence, in the sense that, as we have seen in the numerous earlier examples, like a decision tree, or you can also reduce the legal rules to a decision tree. So their argument, which we have made even earlier, algorithms work as a functional equivalent of a legal rule, not the normal or the identical equivalent, but the functional, in the sense that what the legal rule does, algorithm also does. Maybe the legal rule is written in the way we understand, although not all of us will be familiar with legalese. Algorithms are coded, they do their calculations in a different way, but the rules are the same, or the rules that run on the algorithmic decision making systems, and then the corresponding rules which normally which are being run or which are being used could be the same. So the command consequence structure is being maintained. We need to really study the legal rules as well as mechanisms embedded in them, because there is a new discipline emerging as algorithmic law. Algorithmic law is a sub-discipline of law which looks at algorithms not as mere algorithms but as part of the legal code. Although they have borrowed quite a good amount of ideas from Lawrence Lessig, and his particularly work on code as law, and then his work on understanding legal principles versus code, and then how this is important in the cyberspace context, where the code operates like a gatekeeping mechanism, or code functions like an administrator, or code decides this way or that way for you. So based upon that scholarship, they have made substantial arguments in this paper, which I think anyone who is interested in algorithmic law and regulation should go through. So if we have to study legal rules in the embedded in the system as part of the emerging algorithmic law, it is very important, which is interesting. So the second point which they are making is, after reviewing literature on regulation of algorithms, which has been there for the past 15 years or so, today we should also evaluate the contemporary experience of the algorithmic decision making and set standards for computer engineers to eventually pass a test programming code that could resemble the evidence-based, justifiable, reasonable, and then prudential activities of legal decision maker or making. Put it another way, we are demanding something very exacting, something very difficult from the people who code and build these systems. So what are we saying? We are saying, fine, we want to evaluate your algorithmic decision making and then set standards. So we are going to prepare you some test which you need to undergo, or the system should undergo, and then we can really say as to whether if system is as good as a person who takes a decision based on law, or does it come anywhere near the legal decision making process? This is equivalent to what Turing proposed decades ago to test as to whether the person in the other end or the system in the other end is intelligent or not. So, in an who would expect in an AI imitation game, can machines provide useful prediction for decision making in the legal domain? They propose something that is similar to Turing test for it. The paper has got a very interesting description about it. And then they make a very interesting view that always it is assumed that humans can do decision making as they have the empathy, and there are core human features like which are essential for lawyering and judges. So they say this view is there, but then don't forget there is also a counter view that you say humans have this specific capacity to become lawyers, to become judges because they have empathy. But there's also a counter view to this, in the sense that why not algorithms be judges, why not ADMs be judges and advocates, or for that matter, why can't AI systems act as advocates and act as judges? Because in the literature there are lots and lots of arguments that AI can really function as a judge, and there are a lot of counter arguments. In fact, this debate has been going on for quite some time as to whether can AI replace a judge, or can AI be part and parcel of a judicial system where there are AI courts run by AI systems. Now in the agent AI age, or when we are seeing emergence of agentic AI, particularly AI agents that are becoming more and more sophisticated, that can handle different tasks, and then that can also handle a lot of query based replying and understanding. It is possible that an AI agent can function as a quasi judge who will do the first round of vetting, who would do the first round of analysis of evidence, and then who would do the first round of understanding the arguments, and then come up with a preliminary judgment. So technically, today's AI agents, with their increasing capacity to reason, argument, and then assemble evidence, and then collate data, and then analyze them, it is possible that AI, whether it emerges as a full-fledged judge or not, AI agents may emerge as quasi judges or judges which can help the judges to come up with decisions. So this possibility, which was not there earlier, has arisen now on account of the developments in technology. So maybe in later few years, after few years, we may have quasi AI advocates, we may have quasi AI agents acting as quasi advocates and quasi judges, or as members of tribunals, in the sense that they can replicate those tasks if they are given enough data and training. Coming back to this, they also point out one thing. There is an idea called smart law, which unfortunately we won't cover in this course. Scientific, mathematical, algorithmic law. This is again shaped by risk and technology, in the sense that smart law tries to bring in the rigor of computing, algorithms, and then mathematics, that is statistics, and then science into law. So smart law, and then the ideas that AIs can be judges, and then the thinking that a good amount of the good portion of the judicial system can be taught as code or can be reduced to code, or the good idea or good portion of the legal system themselves can be translated and used as code, or the ideas which again and again tell us that this is not simply technocentric view. Let us also keep that in mind. This is not simply a technocentric view. This is a view that finds the parallels or the equivalence between law and the code, and then the way law operates, and then the way code operates. And then it is also possible that the legal process itself could be more made within courts, more scientific, more proof oriented, and then run by statistical formulae, and also an algorithm AI system can handle it much more efficiently, in the sense that they can do regression analysis, they can whole lot of statistical reasoning they can do. So the idea of smart law or AI judge is not a mere technical perspective. It is a perspective that many people argue that it will improve the law, it will improve the legal process, and it will make law and the legal process much more scientific, much more accurate, and much more convincing because it is based on science. It is not based on mere legal norms or legal values or human rights or anything. So making law more within quote scientific is the idea behind smart law. The technology today is available for it. So the question here is that should we go for such choices even if it is technically feasible or is it morally acceptable? So there are 2 or 3 views in this. We can use them to aid the judges but not beyond that. Other view is that given the capacity, given the way technology develops, we should not eliminate the possibility of they becoming judges or they doing judicial functions. So that there is also a third argument which could be put between these two, beyond these arguments, that in circumstances we can use AI judges but with human intervention, in the sense that there should be a human who should oversee that, and then this will also help us in addressing many things which the legal system or the justice system today is not able to address more efficiently and much more economically. So how do we use AI systems as judge is also something that is related to algorithmic justice, because our fundamental problem here is, we have been arguing, is that algorithmic justice demands something as justice. It is not something that calls for a technically sweet justice. One way which the editors have argued is that some activities are considered to be essentially human, that our society will value the presence of human in the loop and the decision maker. So AI and robots may carry out the services and activities we no longer want to perform. In this, we should carefully examine whether we should prefer to be judged by human intelligence or by AI. So this is what the argument they make. Algorithmic law and regulation challenges everyone to rethink power, democracy, regulation and institutional design. This is an inevitable because algorithmic justice precisely engages with these questions. Now coming back to the point which they have raised, which again they really cite a legal scholar Walkin. In a warfare, is it better to use robots and then automated systems run by robots, or is it better to use humans? The problem here is that a society may feel that it is better to use humans because no human will lose their life, or it is better to use robots and such systems for the simple reason human life is precious and then a whole lot of accountability will come, and then if 1,000 soldiers get killed or 2,000 soldiers get maimed in a battle or in a war, lots and lots of questions will come, families will complain, people will be very upset that we lost so many lives in it. But if you are going to use robots in that, the problem is eliminated, in the sense that at least as of now, we don't consider robots as humans or equivalent as sentient beings. So they build upon this logic and then they argue algorithmic law and regulation challenge everything to rethink power, democracy, regulation, institutional design. So based on these principles and based on these arguments, one way to look at potential solutions is this. We need to differentiate what exactly we are looking at from the ADM or AI systems. Many AI-based systems in sectors like health and enable AI to diagnose, suggest solutions and make recommendations. But in AI systems can identify the need for a cataract surgery and may recommend. But it is left to the humans to decide, although expert can agree with the finding of the AI system. Or AI system here is more like a recommender position. It is not the one that's the final arbiter, or it's not the one anyway that is going to do the operation unless you are going to club that with a robo which that could perform surgery. So an argument is that, which is again very interesting and perhaps also somewhat convincing to some extent. As in some sectors, AI expertise can be as good as that of a human being. So there is no harm in using AI. For example, in health, if the AI's expertise is as good as that of humans, why not use it? If the AI can evaluate papers of the students, like any other professor, provided it is given to it in the form, it can understand and make sense and then evaluate, what wrong in doing it? In the sense that wherever possible, if AI can come to this level of expertise with domain knowledge and then it is being trained in it and it can be proven or it can be used in a non-controversial way, we can go for it. Similarly, in law and justice too, the argument which goes is that AI can give a recent solution or a finding or can justify its order. In the sense that as systems become more sophisticated, Some of the problems like opacity, transparency, or labeling them as boxes will get reduced, and systems will also be able to explain better, reason better, and come up with 100% explanation like any other human would do. But can that per se justify that we should employ them as judges, particularly in the way that we look at algorithmic justice? Or should we take a view that an AI can be an advocate, but AI can be a judge? It is not permissible, but we can use AI advocates and AI judges as proxies or in some context. It can be argued that, as I said, these are opacity, these things can be addressed. So the counter argument goes is that many of the concerns which are raised on account of the algorithmic justice discourse and narrative can be countered by better systems which will be less discriminatory, much more technically sophisticated, very less biased, and as good as, if not better than human decision making. So, how to use AI, how not to use AI can also be reduced to the level of technical efficiency and then technical potential. Then comes another approach or another way of thinking, which people are also now talking in terms of inclusive, bringing in inclusion right from the beginning. So there are ideas like inclusive design, inclusive development of software, and then bringing users and developers together. I mean, these ideas they are in other disciplines, in other applications like participatory plant breeding, then user-led innovations development, where the users also play a major part. So Siddharth D'Souza, whose work we have already cited and discussed in the context of use of AI by Supreme Court, comes up with a very interesting proposition that users and then developers can collaborate the systems based upon the lived realities of the persons. So our major argument is that you are trying to reduce people to statistical numbers, you are trying to disaggregate and then to reduce them to data, numbers, potential, possibility. The potential or the possibility of this person committing a crime is 27.3%, but still he cannot be given a bail that on account of these things. Or the probability of this person jumping the bail and then committing the crime again is 80% based upon his previous behavior and based upon other parameters. So we are saying that if people's lived experience can be brought in, how do we bring in them? What sort of values we assign them is a different question. That is a question of not just technology, but also a question of bit of social science understanding and methodology. He says careful legal design can address many of these problems, but still, in the absence of a careful legal design, more exclusion and marginalization will occur. Or to put it in other ways, legal design can alleviate or can address some of these concerns raised again and again by people who talk of algorithmic justice. But that need to be done with care and that need to be done with caution. Another solution which has been in vogue, which many companies are doing, which in fact many of the consulting firms which develop and then deploy AI systems also do, is to develop algorithmic audits. Algorithmic audit, having an algorithmic audit is also a good practice because that will tell you whether your systems are compatible within some selected AI ethics codes or whether they fulfill some AI ethics norms. These things we will see in detail in the sessions on AI ethics. So algorithmic audits can be another solution because algorithmic audits are not something you do in the algorithm for the first time and then forget it. Algorithmic audits are talked of in the continuous sense that as and when the system gets improved or as and when the system becomes updated, we should do. No, that's not the way. Algorithmic audits can be done where the outputs can be compared, and then if there are inherent biases that get reflected, that can be addressed by auditing them and then by trying to recode or redevelop the system. Another solution which has been propped up or which has been proposed is that we need to bring ethical committees to evaluate algorithms, and this is a good solution because ethics committees understand these problems in a very acute way because ethics is not a very dry domain. And then there are different schools of ethics, different thoughts on ethics, where people talk about normative ethics, you have Aristotelian ethics, you have pragmatic ethics, and then these different schools of ethics also have different perspectives on understanding human suffering, understanding the impact on humans by different systems. And in particularly speaking, ethics, some disciplines like bioethics can really open up many things for us to understand better. So ethics committees, which are normally there as part of doing clinical trials or experiments in hospitals or for any large-scale experiment involving humans, similar ethics committees can be used, which deal with the algorithms, the inherent biases. They can assess them on the basis of ethical principles and then parameters. Then another idea which has been brought in is bringing responsible AI and explainable AI. This we have already discussed in the sense that this solution, but we will discuss both these concepts in much greater detail in subsequent classes. But the fundamental question in all these things is that what do we want to address or to solve, and what are the trade-offs we are going to agree to? So what do we want to address? And what we want to address, is it a mere question of opacity in technical terms, or are we talking in terms of a larger solution in the sense that opacity of 15%, 10% is okay, provided some of the other things that are related to bias and discrimination are fully addressed, or black box is 95% transparent, 5% black box, or there's a trade-off, an ADM which is proved to be more biased and seems to be having more discrimination. If it is that's the major weakness of that. If that could be addressed and technically made better, there could be minor other problems in the sense that there could be still some discrimination, some bias. Can that be taken as a good example that a much improved system is better than a previous system? So what are the trade-offs we need to bear in mind? In the sense that these are some of the solutions if there is an idea that AI systems can be deployed. If they can be deployed when they are made better. So the normative principles, if they can be brought into the AI systems, and then if ethics committees can evaluate them based on ethical parameters, and then if people can come together as Siddharth Desausa has pointed out, with a legal design, carefully taking into account the lived experiences of the people, stakeholders coming together, teaching the people who are trained in algorithm and then software and then engineers to bring in human elements, to bring in some ideas about how they can assign values or how they can come up with better solutions. Can that result in meeting some of the needs of algorithmic justice? The answer is wide open. We really do not know, because the topic of algorithm justice itself is quite new, as we said, and then some of these debates have been happening only for the past 15 or 20 years in a much more concrete way. Although you might find that discussions about using AI in legal system or particularly in as judges is much more old, in the sense that they have been thought of as solutions even much earlier. But we also need to look at some sort of things with a pinch of salt. A normal solution or a normal approach is that there is a gap between the public and the government, and then public often is not able to approach the government officers, service providers and others because of a whole lot of other problems, including people not being available, too crowded, or insufficient human resources with the government. So government departments are using more and more digital tools, including the chatbots, including do-it-yourself tools for the people who can really use them to address some of their concerns. And of course, there are a whole lot of ways governments try to automate their own operations. And if these can be expanded to legal service, in the sense that I am sitting somewhere in 300 kilometers from the capital city where the High Court is situated, I need some legal clarity on whether my understanding of this legal issue is right, because I want to file a petition in the nearest court to me. Can I have an AI-based system that provides legal service? It provides legal guidance. It could be an interactive AI bot. It could be a web-based decision making tool that can also help me in the sense that we can stimulate. An AI tool can also stimulate in the sense that I input questions, it gives me answers, then we simulate a game or we simulate a situation and to arrive at what could be the potential solution or what could be the potential way out. So there are so many possibilities are there. It can also be a good source for information. But Recent study by two professors in the US, Blank and Ofsky, this is a very interesting book which I would recommend anyone to go through. They say the reality is different because they find one thing, that the promises made or the promises or the potentials assumed that more and more use of AI tools or more and more use of such digital technologies in legal systems, particularly in government systems, is going to make things friendly, is making things easy for people. Often that translation is not 100%, or there is a huge gap between the potential that is expressed versus what is actually realized. Here they point out something which is very pragmatic, which is all the more relevant for countries like India. However, the use of automated legal guidance also comes with important cost. Critically, we show how, precisely because the perceived strength when compared to the often messy, ambiguous formal law, automated legal guidance can obscure what the binding legal provisions actually are. In the sense that the legal provisions can be smoothened and then it can give you a very short, crisp answer, which could be valid, which could be acceptable, but then it will not go into the complexities. Or what the legal system assistance provided through an AI system can give to you is something like a solution that looks perfect, that looks understandable, but then what is not said by the system or what it did not caution you is more important. To put it another way, as I said, someone approaches this AI based tool for some assistance. It can come up with a solution, it can say something very specific and then say you do it. But it is also possible that it is trained in such a way that it identifies only one solution, or it is directed towards choosing that as the best solution for the person who asks this question. In contrast, when I go to an advocate or when I go to a legal counselor, that legal counselor will have a broader perspective and will also have a broader understanding and then try to tell me the various other options and then tell me this is a process which will take more time, and if you go to the court by invoking these provisions and asking for this relief, it is feasible, but then the probability is not all that high. On the other hand, this process, we invoke these provisions and then if we use this act, or if we totally go to a different forum, instead of going to court, if I go to a tribunal, you may get a better judgment or it could be faster. So an advocate can open up all the options, taking into account my priorities, my concerns, at the same time legally sound. But their experience with their case studies show them this is not something that is happening with the legal AI agents. Because the legal AI agents give them crisp, quick answers, but then that is not the true and full picture. Now, I am fighting a case against the government. I have filed a case against the government. So the government is recommended by the government pleader or the public prosecutor. I, as a person, if I rely on the advice given by a legal tool which the government itself has nominated or has made available, can I really expect that the public pleader or the government pleader or the public prosecutor will 100% use the same arguments or will 100% agree with what this said? No. It could be totally different, because the pleader or the public prosecutor or the government advocate is a person who will look at other possibilities, including counter arguments, who will also look at various other precedents, binding precedents, which cases where what should be argued with clarity, what should not be touched upon, or where the case law can be used and cited with confidence. But a legal service tool may not be that efficient. More importantly, it may not even happen that the argument put by the legal tool is the one that the advocate representing the government will put in the court. Both could be very different, both could be totally different also. So their problem, they say, is that the real world life experience of people in courts, in tribunals, advocates is something, whereas the advice given by the legal tools, AI based tools, is something that's totally different. Or the ground reality is something which a tool may not be able to really grasp and give us advice, or the advice given by the tool may be legally sound, perfect, but then the ground reality of the public prosecutor or a pleader coming up with totally new set of arguments cannot be wished away. So, other thing which they also point out is that often what happens in such circumstances, if an AI tool is the only option available to me, I am too poor, I will use it, I will rely on it. But those who are much more financially secure or who can explore other options will not simply relate to them. They will try to guess the best option, they will go to more than one advocate, or they will consult different people for this. So when AI system can really provide AI legal assistance, that is perfect. They may not be able to give the right and exact legal advice we need. But the problem here which we need to address is access to courts and then solving that through AI boards or AI legal system, because they get better access, is only for one part of the problem. The other part of the problem is that people are too poor or they don't have the capacity and mobility to go, is a different problem. Now, we cannot substitute technology as a sweet solution without trying to think of the other problem, that is poverty or lack of financial services or lack of financial resources to go to court. So lack of one cannot be 100% be substituted by another one and say we have found a fantastic solution. You are stuck somewhere 300 kilometers away, and then you can use AI system, you can do remote counseling through AI system. So this sort of thing where the reality and good intentions are different is something we need to be very, very careful. And then why this makes an important point in the context of algorithmic justice is that algorithmic justice demands full justice, or algorithmic justice does not believe in finding speed technical substitutes and then promoting them as good solutions that will give us algorithmic justice. Now, there is a very interesting observation made 5 years ago in a Stanford Technology Law Review. This is an interesting article which people who are interested in law, justice and technology should really read. After exposing into the way artificial intelligence and justice has been talked about in the literature, the pros and cons of that, how different schools of thought have discussed it, their final words are this: as AI is increasing use in judiciary makes codified judiciary more appealing in other countries, its downsides are likely to be reproduced too. In the sense that when America does codified justice through AI, when some other countries repeat the same thing, the downsides will always be there. Problems analogous to one discussed above are likely to arise, and the basic minimum responsive with all limitations likely to recur. So, finding a path that will require attention not only to technology and law, but also to technology's impacts on the conception of justice, which we have discussed in the context of ADM, which we have discussed in the concept of AI in the context of rule of law, in both human artificial intelligent forms. In other words, what exactly is the technology impact on conceptions of justice in human intelligence and then artificial intelligence is very important. Or this is the final word which cautions us that do not take things granted, or you can development artificially intelligent justice may be possible, but still this is something which we cannot wish away. In another context from a different country, and then this is a report which is an eye-opener, which could be an eye-opener for many of us. It was the House of Lords Committee report of 2022. They appointed a committee that went into the application of new technologies in justice system. They did a thorough job of getting stakeholders' views, looked at different technologies including facial recognition technologies, and then they have a lot of things to say about algorithms, but then due to lack of time and other things, I am not fully reproducing them. In fact, one thing which they said, a country does not have any algorithmic registers, in the sense that there are so many algorithms used by different public agencies, by municipalities, by police, by this, by that. But there is no central registry where you can say that this agency has this algorithm being used, and then this is developed by him, and this is exactly what the major it does. So, in the absence of algorithmic registry, algorithms being spread around across gives the situation that the users or the stakeholders or the ones who use these systems are not talking to themselves. And then another point which they made is that each agency wants to come up with a technical solution in terms of algorithmic decision making. So it goes for a bidding, it goes for calls, it goes for people to develop and then deploy. But then these are being often done without full understanding or without the need to develop standards or without the need to assessment. And often these are also done without the proper technical assessment of them. In the sense that when public service utilities, public service authorities, they go for some of these technical solutions, including algorithm based decision making, they do not pay adequate attention into the things which they should pay. Instead, what happens is that they either rely too much on technology, or they think that technology can get us the solution which will be much more efficient. But the observation which they have made is something which cannot be wished away, because it will be, they are very valid for all countries including India. When deployed within the justice systems, AI systems have serious implications for a person's human rights and liberties. At what point someone be imprisoned on the basis of technology, that cannot be explained. Informed scrutiny is therefore essential to ensure that any new tools in this sphere are safe, necessary, proportionate and effective. This again is the fundamental principles in which any justice system will work. In the sense that it will not unduly punish a person. The proportionate test and then the necessity test and then the effective test are the benchmarks which judges apply. In the sense that you will not put a person to 20 years in jail for a small crime. That person may be asked to pay a fine or they may be imprisoned for 2 to 3 months. And what they are saying is that this sort of scrutiny is not happening. What they have found or what they have uncovered is that a new Wild West, you all know how it operates, how people operate in that, in which new technologies are developing in a pace that public awareness, government regulation has not kept up pace with. This is something which we also know as a pacing problem, which we will see later, particularly in the context of AI. So, technology rules, the advent of a new technology justice system is an interesting report which also talks about algorithmic audit, which also talks about how some of these concerns should be addressed by public authorities, so that the deployment of these technologies does not result in a new Wild West. To sum up, in these 2 sessions on algorithmic justice, we have barely scratched the surface. This is an important emerging theme with multiple views with pessimism and optimism. That is obvious, it could be expected. So, for every why of using ADM, there is an equivalent why not of using ADM. The literature is vast and expanding. So, this discussion should be seen more as a partial introduction to the topic than as a grand exposition to the topic. And the literature cited in the presentation has been given, but there is more can be added. So with this, we are winding up the 2 sessions on algorithmic justice. The next session is going to be something on copyright. We will devote 4 sessions on copyright for AI and copyright. And then AI and copyright being a very hot topic and emerging topic, we will address threadbare some of the key emerging topics as well as some of the fundamental questions that are again and again pop up when we talk of AI and copyright. Thank you.